the procedural law will tell us what is the procedure for remedial measures under those substantive laws. Breach of agreement हो गया. If there is a breach of agreement, what is the procedure? We are blank because Specific Relief Act is silent about it. Indian Contract Act is silent about it. Consumer Protection Act is silent about it, except saying that you can file a consumer complaint before a competent district forum or a state commission or a national commission, depending upon the pecuniary jurisdiction. But where is the procedure? Who can present it? What is the procedure to be followed during the adjudication of that complaint or a plaint or whatever it is? So, in these perspectives, either the substantive law may provide the procedure, and we can say that particular law is a substantive and a procedural law. There are certain laws. And the other is the enactments are substantive in nature, then the legislature in its wisdom has made one code that is called Code of Civil Procedure. Wherever no procedure has been prescribed, then the Code of Civil Procedure will govern the proceedings. So this is the first context of Code of Civil Procedure. Code of Civil Procedure governs the procedural part. But there is again another question. It is divided in sections and orders. Why? Anybody can answer it? Civil procedure, yes please. So meaning thereby, Code of Civil Procedure is not here, even the substantive law relates to procedure. This is the difference. Here, the substantive law provided under these sections is again procedural in character. It prescribes the procedure. What is the difference between plaint and petition? Why we are using different nomenclature? We are filing a case before the competent court of law. Plaintiff, petitioner. Why we are using these different nomenclature? What is the reason? Yes, any idea? Sorry?
They were the first one to file a case in a court.
Yes, absolutely right. When I am saying petitioner, plaintiff, applicant, appellant, they are filing the case. So they are all covered by this definition. Why?
Position in the case, like an applicant is filing for an appeal, and the petitioner is filing maybe the first petition before the court to start a proceeding, and if so I think maybe to differentiate where at what stage they are in their case.
Right. Anybody else? Then again my question is, what is this plaint? It is only presentation of your case. Very simple. Why the nomenclature is again used for a similar case for petition?
Sir,
These are very basic things, and we ignore, not during our law school, but even in the profession. We just continue with using these terminology without knowing the भैया पैरासिटामोल का अगर फॉर्मूला नहीं पता डॉक्टर कैसे हो गए, यही सिचुएशन है ना? हाँ बताइए आप.
what plaintiff wants to, what is a fact basically.
Perfect.
In petition, there is like if the court has not if a petitioner is not agreed with the court of a junior district court, like
So that is appeal only. That is appeal. That is appeal. Thank you very much. You have made the effort. I'll explain it. Plaint and petition, whatever your statement is regarding plaint, it also applies to the petition also. You are filing a civil suit. You are right in saying statement of facts, jurisdiction, court fees. So it is a plaint. If you want to get your rights of declaration of your right of ownership for a particular set of properties, you can file a suit for declaration. It is again a civil suit. There are a number of civil suits. You can seek injunction against the other party that this party may be restrained from entering into my house. It is called injunction suit. So these are all plaints. And again, in a Hindu Marriage Act, if you want to file a restitution of conjugal right or a divorce petition, it is a petition, not a civil suit. Right? So why? It is now used as petition, not civil suit. You are going to the original jurisdiction, you are filing a statement of fact. Plaint, basically, when the law originates and codified, wherever the law is, where you have the inherent right to file a case. I am not using plaint or petition. When you have an inherent right to file a particular case before a competent court of law, then it is always a plaint. When a right has been given to you under a law, then it is always a petition. Have you followed the distinction? May I explain it again? What are the inherent rights? If my fundamental rights is violated, my legal right is, my human right is violated, or where there is no right provided under the statutory law, but still I have, being a human being, inherited those rights with my birth, then I have a right to file a civil suit. So whenever there is an inherited right vested in a person and he wants to get it enforced in the court of law, then it is a civil suit. When a right has been defined under the law, then it is a petition. So when a person is filing a plaint, that is a civil suit, he is called plaintiff. It is not the inherited right, but it has been given by the specific relief act. There are certain rights which are inherited in the individual. Now it has merged some way, what the basic distinction is. Now when we file the suit in the original jurisdiction, CPC ਨੂੰ understand ਕਰਨ ਤੋਂ ਪਹਿਲਾਂ, ਕਿਉਂਕਿ ਤੁਸੀਂ CPC in two situations. One, in general law, where I am saying inherited right is there, and I am filing a civil suit, there is no procedure prescribed, then CPC will apply. Or where the specific substantive laws are there, and those substantive laws says that a particular procedure has been prescribed in this law, and the remaining issues regarding procedure, CPC will apply. So, ये गल clear हुई? Now CPC has been divided into two parts, sections and orders. If you are a lawyer, I am your client, I came to you to discuss certain issues regarding my rights, that is what CPC answers. Whatever your queries are there, I have just, being a client, told you about my grievances. Maximum I can hand over the documents. Now you, being a lawyer, have to explore which type of civil suit is to be filed. What is the procedure to be followed? This is what CPC answers. Your each and every question will be answered by CPC. Let's start with it. ਤੁਹਾਡੇ ਕੋਲ ਇੱਕ proposition ਆ ਗਈ. Now you have one proposition. That proposition, whether falls within the civil law or not. Section 9 answers this. Section 9 of the CPC says whether this dispute is civil in nature or not. So first you have to test your proposition whether it is civil or not. If it falls within the category of civil, yes, you can file a civil suit. Next is Section 10. What Section 10 says? Res sub judice. Res sub judice means you ask the client whether any similar suit against the same party is pending or not. He says, yes sir, unne amanu samman ditte hoye ne us case pe. It means you have to now evaluate whether your suit is maintainable in view of Section 10 or not. If it is maintainable, whether the other party may move an application for staying my civil suit. So you have to assess section 10. Then res judicata section 11. बहुत बड़ा वर्ड लग रहा है, बहुत ही सिंपल res judicata जे तुसी पढ़िया होएगा, you have the inclination very tough. Section 11 is very tough. This is the response, but section 11 is very simple. किवें सिंपल है? Party same, issue same, heard and finally decided those issues, decree passed. If a civil suit between the same parties regarding the same issues finally heard and decided, then that judgment, that case will operate as a bar to institute the new suit between the same parties regarding the same issue. This is res judicata. Now there is another word, constructive res judicata. What is constructive res judicata? Constructive means ਜਿਹੜੀਆਂ plea मैं पहले सूट ਦੇ ਵਿੱਚ ਲੈ ਸਕਦਾ ਸੀ, whatever the pleas I should have raised and claimed in the previous suit, but I have abdicated, not taken, that will also operate as res judicata. This is called constructive res judicata. मतलब मैं ਤੁਹਾਡੇ अगेंस्ट ओनरशिप ਦਾ सूट फाइल करता, पोजेशन ਦਾ दावा ही नहीं ਕੀਤਾ, पोजेशन ਦਾ क्लेम ही नहीं ਕੀਤਾ, अल्टीमेटली ओनरशिप ਦਾ मेरा राइट ਤਾਂ एस्टैब्लिश हो गया, पोजेशन मैं क्लेम ही नहीं ਕੀਤਾ. I should have claimed that क्योंकि उस सिविल सूट ਦੇ ਵਿੱਚ it was a clear finding and an argument that other party is in possession. So I have chosen not to claim that leave, but I should have taken in the previous suit. So meaning thereby, by the application of constructive res judicata, I am not entitled to file a fresh suit, even though there is no specific prayer. This is called constructive res judicata. Then place of suit. ਹੁਣ ਅਗਲਾ ਤੁਹਾਡੇ ਲਈ ਪ੍ਰੋਬਲਮ ਕੀ ਆਈ? ਪਹਿਲੀ ਤੁਸੀਂ ਇਹ ਦੇਖ ਲਿਆ ਕਿ ਇਹ ਪ੍ਰੋਪੋਜੀਸ਼ਨ ਜਿਹੜੀ ਹੈ ਸਿਵਲ ਇਨ ਨੇਚਰ ਹੈ. ਸੈਕੰਡ ਤੁਸੀਂ ਦੇਖਿਆ ਕਿ ਰੈਸ ਸਬ ਜੂਡਿਸ ਅਪਲਾਈ ਨਹੀਂ ਹੁੰਦਾ. Previously ਇਹਨਾਂ ਪਾਰਟੀਜ਼ ਨੇ they have not filed any civil suit. So you have crossed those three hurdles. Fourth is where to file the civil suit. Section 15 to 20. Those answers are lying in section 15 to 20. भाई कितने सिविल सूट फाइल करना है, केड़ी कोर्ट फाइल करना है, सब कुछ जिथे सब्जेक्ट मैटर है, जिथे ऑर्डनरी प्लेस ऑफ रेजिडेंस है, जिथे ऑर्डनरी प्लेस ऑफ बिजनेस है. मैं नहीं पर्टिकुलरली पढ़ा रहा, तो आई एम जस्ट गिविंग यू एन ओवरव्यू हाउ टू प्रोसीड विद द सिविल सूट बिफोर फाइलिंग इन द कोर्ट. सो इत्थे आपां डिसाइड की कीता, व्हाट वी हैव डिसाइडेड नाउ कि दिस पर्टिकुलर कोर्ट हैज द जुरिसडिक्शन टू फाइल द सिविल सूट, राइट? कि इत्थे ही नाउ द थिंग्स आर ओवर एंड वी शुड जंप इनटू द कोर्ट ऑफ लॉ एंड फाइल द सिविल सूट. माय आंसर इज नो. सो दीज आर ओनली द 4 steps which you have to ascertain before drafting a civil suit. I am saying before drafting a civil suit. ਹੁਣ ਮੈਂ ਤੁਹਾਡੇ ਕੋਲ ਆਇਆ, ਮੈਂ ਕਹਿੰਦਾ ਜੀ ਮੇਰੇ ਕੋਲ ਤਾਂ ਪੈਸੇ ਹੀ ਹੈ ਨਹੀਂ, ਗਰੀਬ ਆਦਮੀ ਆ ਮੈਂ, ਤੇ ਮੇਰੇ ਕੋਲ ਕੋਰਟ ਫੀਸ ਦੇਣ ਦੇ ਵੀ ਪੈਸੇ ਹੈ. ਕੀ ਸਾਹਿਬ ਕਹਿੰਦੇ ਵੀ ਠੀਕ ਹੈ ਮੈਨੂੰ ਫੀਸ ਨਾ ਦੇ, ਪਰ ਕੋਰਟ ਦੀ ਫੀਸ ਤਾਂ ਦੇਣੀ ਪਏਗੀ. ਕਹਿੰਦਾ ਮੇਰੇ ਕੋਲ ਕੋਰਟ ਫੀਸ ਦੇਣ ਦੇ ਵੀ ਪੈਸੇ ਨਹੀਂ. ਤਾਂ ਤੁਹਾਨੂੰ ਕਿਹੜੀ ਪ੍ਰੋਵੀਜ਼ਨ ਹੈ CPC ਦੀ ਜਿਹੜੀ ਆਥੋਰਾਈਜ਼ ਕਰਦੀ ਹੈ to sue as a pauper, to sue as a indigent? Means ਗਰੀਬ ਆਦਮੀ ਆ ਤੇ ਮੇਰੇ ਕੋਲ ਕੋਰਟ ਫੀਸ ਦੇਣ ਦੇ ਵੀ ਪੈਸੇ ਨਹੀਂ ਹੈ, ਤਾਂ ਉਹਨੂੰ ਕਹਿੰਦੇ ਆਪਾਂ pauper ਔਰ indigent person. ਤਾਂ ਇਹ ਦੇਖਣਾ ਪਏਗਾ ਜਿੱਥੇ ਆ ਕੇ ਤੁਹਾਨੂੰ ਕਲਾਇੰਟ ਨੇ ਕਹਿਤਾ ਕਿ ਮੇਰੇ ਕੋਲ ਕੋਰਟ ਫੀਸ ਦੇਣ ਦੇ ਵੀ ਪੈਸੇ ਨਹੀਂ ਹੈ, ਤਾਂ ਤੁਸੀਂ ਦੇਖਣਾ ਆਰਡਰ ਕਿਹੜਾ 33 ਜਾਂ ਸਮਥਿੰਗ ਲਾਈਕ ਦੈਟ. ਉਸ ਆਰਡਰ ਦੇ ਵਿੱਚ ਕੀ ਰਿਕੁਆਇਰਮੈਂਟਸ ਨੇ, ਕੀ ਰਿਪੋਰਟਸ ਚਾਹੀਦੀਆਂ ਨੇ, ਤਾਂ ਉਹ ਰਿਪੋਰਟਸ ਤਿਆਰ ਕਰੋਗੇ, ਉਹ ਕੰਪਲੇਂਟ ਨੂੰ ਔਰ ਐਪਲੀਕੇਸ਼ਨ ਨੂੰ ਅਕੋਰਡਿੰਗਲੀ ਤਿਆਰ ਕਰੋਗੇ ਤਾਂ ਕਿ ਕੋਰਟ ਤੁਹਾਨੂੰ ਐਜ਼ ਇੰਡੀਜੈਂਟ ਪਰਸਨ ਕੇਸ ਕਰਨ ਦੀ ਪਰਮਿਸ਼ਨ ਦੇਵੇ. ਠੀਕ ਹੈ, ਹੁਣ ਇੱਕ ਇਹ ਪੁਆਇੰਟ ਆ ਗਿਆ. ਸਪੋਜ਼ ਉਹ ਬੰਦੇ ਕੋਲ ਪੈਸੇ ਹੈਗੇ ਨੇ, ਕੋਰਟ ਫੀਸ ਹੈਗੀ, ਨੋ ਇਸ਼ੂ, ਬਟ ਜਿਹਨੇ ਸੂਟ ਫਾਈਲ ਕਰਨਾ ਹੈ, ਜਿਹਦੇ ਰਾਈਟਸ ਅਲਟੀਮੇਟਲੀ ਡਿਟਰਮਿਨ ਹੋਣੇ ਨੇ, ਉਹ ਮਾਈਨਰ ਹੈ. ਹੁਣ ਕੀ ਕਰੋਗੇ? ਉਹ ਲੂਨੈਟਿਕ ਹੈ, ਉਹ ਇਨਕੰਪੀਟੈਂਟ ਹੈ ਟੂ ਫਾਈਲ ਅ ਸਿਵਲ ਸੂਟ ਅੰਡਰ ਦੀ ਲਾਅ. ਤਾਂ ਕੀ ਕਰੋਗੇ? ਯੈਸ, guardians, next friend. law padhan lagya, whenever you study law, whatever come before you, give a thoughtful consideration to that word. Go to the dictionary, go to the amendments, find out the real answer. Next friend means a friend of the court and the friend of that incompetent person. Guardian is when under the Guardian and Wards Act, he has been specifically appointed as guardian. So there are two. One is under the CPC, we can file a civil suit through an ex-friend. Any person who has no adverse interest to the incompetent person, maybe father, maybe mother, maybe aunt, who has no adverse interest to that person, may become an ex-friend and file a civil suit. Other is minor, under the Guardian and Wards Act, move an application, get myself appointed as a guardian, and then file the suit. This is the only difference. Both are competent. एक इशू ये खड़ा हो गया कि इनकम्पिटेंट पर्सन है तो आप उनको डिटरमिन करना है कि हुन किस वालों सिविल सूट फाइल होएगा, किस वालों माइनर वालों या इनकम्पिटेंट वालों, बट थ्रू अ नेक्स्ट फ्रेंड और अ गार्डियन. सपोज गार्डियन अंडर वार्ड्स एक्ट में ऑलरेडी गार्डियन अपॉइंटेड है. One. Second, mother and father are natural guardians. So the word, you can use the word guardian because there is no requirement of appointment of guardian. The natural guardians are there. ये इशू भी नहीं है. सपोज ਹੁਣ ਤੁਸੀਂ ਸਰਕਾਰ ਦੇ ਅਗੇਂਸਟ ਕੇਸ ਫਾਈਲ ਕਰਨਾ, ਗਵਰਨਮੈਂਟ ਦੇ ਅਗੇਂਸਟ ਫਾਈਲ ਕਰਨਾ, ਤਾਂ ਕੀ ਕਰੋਗੇ? Where is the answer lies? Answer lies in this field again CPC. सरकार के अगेंस्ट केस फाइल करना है तो की रिक्वायरमेंट है? हैव यू रेड सेक्शन 80?
Notice. Yes.
Yes.
Notice 2 months.
Notice to
Government.
government. For how much? I am working under the state of Punjab and I have certain issues regarding my promotion, regarding my increment, regarding my any other service benefit. I have to file a civil suit against the state. Then I have to file that I may be dispossessed tomorrow by the state, and if I serve 2 months notice, my relief may become infructuous by that time. Is there any provision which gives the answer to this situation? Yes. If you have read section 80, it gives the exception also. It says in case you prove there is an urgency, the period of 2 months notice may be waived off. So this has also been answered by the CPC. Similarly, if you have to file for and on behalf of or against the corporation, against the company, again CPC will answer how to frame your suit, how to frame your memo parties. So CPC will give you the answer to all these questions and then you start your drafting. It is not that client आया उन्हें 4 स्टोरियां सुनाइयां तो उन्हें जेडी स्टोरी अच्छी लगी लिख देती और केस फाइल करता. No. You have to understand each and everything. Go through CPC, get the answers and then start your drafting. Jurisdiction, whether where you are filing, whether the court has the jurisdiction under section 15 to 20, you have to get the answer. So before drafting, you have to get all these answers. This is one aspect. Second is, now whatever you are averring in the making the averments in the plain, you have to prove those averments. If you are stating certain facts in the plain, you have to prove those facts. Without proving those facts, can you succeed? Answer is no. So whatever you are making the averments in the plain, you have to think whether sufficient evidence, do you have the sufficient evidence to prove it? Who will become a witness to prove this fact? What document will be there to prove this fact? If I am claiming I am the owner of this particular property and I know that Jamabandi is declaring me as the owner or a particular sale deed, registered sale deed, is declaring me as the owner, whether that document is available with me, whether the person who will prove it is available with me as a witness. If there is a dispute regarding will, there are two witnesses, whether those witnesses are living or dead, whether this will is registered will or not. If it is a registered will, whether I can get it proved through the office of the registration. So you have to think on all these aspects. It is not a story that you can put before the court. You have to prove those stories before the court of law. Only then you can succeed. So first aspect is scan these facts, scan the provisions of the CPC, and then decide the drafting of a civil suit. It is not that civil procedure code only prescribes the procedure that पहला प्लेट आप गलत फाइल कर दी उसके बाद प्रोसीजर CPC का फाइल प्रिस्क्राइब होगा नहीं तो उन्होंने CPC ये भी गाइड कर दी है कि सूट फाइल करने तो पहला भाई ये सारियां रिक्वायरमेंट्स देख लो वो रिक्वायरमेंट्स देखने तो बाद फिर अपना सूट प्लेट ड्राफ्ट करो so first aspect is this now there is a procedure now you have to file a civil suit in the shape of a plaint the court will entertain. Now what is the procedure before the civil? With the presentation of the plaint, what is the procedure? Can anybody explain it? Have you ever visited the civil court for internship or something? Now, there is a complete procedure prescribed under the CPC how to serve these summonses. In the appendix, even the format of the summons are given. You should not go to anybody. CPC itself gives you the format of summons. Then, if the summons are received by the defendant, he will appear or he may not appear. It is the choice of the defendant. Suppose the service has been effected on the father of the defendant. Suppose the service has been not effected because the address given is wrong. You can find out the provisions under order 1 that how to serve the defendant who is not residing there, who is residing abroad, or the service has been effected on the father or a family member. What is the effect of that service? Now service is complete. Defendant has chosen not to appear. Then the court has to pass an ex parte order. The court may proceed that he has been sufficiently summoned, served, still he has not chosen to appear before the court, he may be proceeded ex parte. But whether merely by ex parte order passed against the defendant, your civil suit will be allowed? No. Court has to follow the procedure. The plaintiff has to prove his case. Plaintiff has to stand in his own legs. He has to prove all the facts which he has narrated in the plaint by way of a sufficient evidence. And then the court may consider whether he is able to prove his case or not. If he is not able to prove his case, even ex parte case may be dismissed. But if he is able to prove it, then the court may allow. Now coming to this, defendant appear, he may file the written statement. Again, a period has been prescribed. Within how much time you have to file? Within how much time you have to file the written statement?
30 days.
Pardon?
30 days.
Whether this provision of 90 days starts with shall or read accordingly.
30 days is shall and then it's may.
You are entitled to give sufficient reasons and get the delay condoned. Whether this section 5 application is there for condonation of delay in filing the civil suit. very important. You just file an appeal, 90 days period is prescribed, you file on the 100th day, you may move an application because of ABC reasons, I am not able to file within 90 days, the period may be condoned. But in a civil suit, suppose it's a recovery suit, Limitation Act prescribes 3 years. The answer is no. Just read section 5. It says application, appeal, revision, everything, but not this suit. In the case of civil suit, period of limitation cannot be covered. So now coming to this written statement, averments of the claim. Now this gentleman has asked this question, how to file the written statement. Each court has a different procedure for filing the written statement. If it is a civil court, you can file in the registry of the civil court, you can even file in the court itself also. There is no prescribed application is required. But if you are filing in the High Court, there is a prescribed procedure, you have to move an application and file in the registry and then it will be taken. Or if there is a period of more than 3 days is there for filing the written statement, you can file in the registry of the court with a forwarding letter that I will be permitted to place on board the written statement. After the filing of the written statement, the plaintiff may be given the opportunity to file the replication or rejoin. Meaning thereby, whatever has been stated by the defendant in the written statement, the plaintiff may admit or rebut to those averments. Now, after the replication, pleadings are complete. This is called pleading. CPC, there is a provision part 1, preliminary, which contains section 9, 10, 11, 15 to 20, then place of suing, and then the pleadings. Whatever are the pleadings before the court. Now pleadings are over. Now after the pleadings are over, now it is the duty of the court to frame issues. What are the issues? Issue means the bone of contention. In the plaintiff has made certain averments. In the written statement, the defendant has either admitted or denied those averments. The court will examine those pleadings and frame certain bone of contention or issues before the court. We will take an example. Suppose there is an agreement. The issues framed by the courts. Have you seen either the judgment of the civil court or the proceedings before the civil court? Have you seen anybody? Have you seen the real format of issues? Yes? In capital. Have you seen that? Yes. Question mark is there, question is complete. Then there is 3 words in capital are written against each issue. And those issues or these points have to be established either the plaintiff or the defendant. Plaintiff or defendant has to prove this. It is called onus to prove on the plaintiff. Similarly, another question, whether this agreement to enforce the consent has been obtained say by tolling. This is very important. Yeah, that you must understand. There is a provision in the CPC regarding issues, framing of issues, notice to discharge a particular issue. There are provisions. But how to understand in the procedural part particular issues in this circumstance? The court shall frame those issues and also mark which party has to prove that particular issue. So if defendant is saying that my consent has been obtained by fraud, misrepresentation, then he has to prove this fact the plaintiff is saying that this agreement is enforceable by law, then under the Indian Contract Act, whatever the requirements are there, then the plaintiff has to prove that this agreement is valid in law, consent has been obtained and in accordance with law, and it is neither avoidable contract, not a void, but enforceable by law. So the onus is now, how can they prove? The next question is, how can they prove? Suppose they witness, suppose उसका witness PW1 है, तो दो तरह का evidence होता है, chief and cross. Now in the cross means defendant will cross-examine this witness. He may ask these questions, an opportunity to the plaintiff to rebut the evidence of the defendant. That is called rebuttal evidence. And thereafter, the case is closed. The court will hear the argument. Seems to be very simple. But is it so? It's not. You are carrying, there was a flood, you lost that agreement. But you have a photocopy. Whether you can adduce the secondary evidence, whether the secondary evidence. So all these things, it is now, it is not only the CPC. You have to understand this procedure with the evidence. I am saying Evidence Act, you just, nomenclature is changed. It is the Evidence Act. Without understanding CPC and Evidence Act together, ultimately, if we understand this, first part is drafting, second part is presenting the claim before the civil court. After the presentation, summons are issued, completion of summoning, written statement of the defendant. Then on the basis of the pleadings, the court will frame the issues and ascertain which issue is to be proved by which of the party, that is OPP or OPD. In the appellate court, it may be OPR, respondent. Then the plaintiff will be given an opportunity to produce his evidence, both oral and documentary. How can we prove the documentary evidence? Again, Evidence Act will help us. How to cross-examine? Again, art of cross-examination. Can you put the leading question? Answer is no. What is the leading question? Right? Pardon? What is the leading question?
You have to apply, you have to reply yes or no.
Okay. Yes. Suppose there is a witness produced by the plaintiff and he refused to give the answers to the plaintiff's counsel in the chief. Can in the civil proceedings a witness may be declared hostile to the effect that I may be permitted to ask the leading question in the civil law? Yes? On the strength of their pleadings and the evidence, and prove that the owners of particular issues they have completely discharged.
Whereas in a decree, only the rights and liabilities of the party as specified in the judgment are specified.
Perfectly right. Judgment is basically, we can say, the reasoned decision of the court. The court gives the reasons why I have reached to a particular conclusion on a particular issue. So it is a reasoned decision, where the court will discuss the pleadings, court will discuss the evidence, court will discuss the issues, and finally on each and every issue, the court will give its verdict by giving the reasoning. Whereas the decree is only a formal declaration that these rights have been declared, or these duties have been declared, or this particular way of deciding this civil suit. It is a formal expression. क्यों मैं कुछ दिन पहले ये चीज़ बारे पढ़ रहा सी, ये क्यों किया गया जजमेंट और डिक्री वक्रा इकट्ठा क्यों नहीं किया? What is the history behind it? वो उस विच ये आया कि जेडे आम पब्लिक है उन्होंने नहीं समझ लगती कि जज ने की फैसला किया है, उन्हें किवें एविडेंस किवें रीजन दिते हैं, वो आम पब्लिक को नहीं पता लगता। तो डिक्री उनके वास्ते है कि भाई तेरे केस हक च हो गया, तेरे केस अगेंस्ट हो गया। तो एक उस पब्लिक वास्ते सी डिक्लेरेशन कि भाई तेरे वो लीगल शेप दे विच डिफरेंट कॉनोटेशंस आ गई, बट पर्पज इहदा ये सी कि आम बंदे नूं पता लग गया कि मेरा केस मेरे हक विच होया या मेरे। सो दिस इज वन पार्ट ऑफ द CPC डीलिंग विद द सिविल सूट्स। एनी क्वेश्चन, एनी डाउट? डाउट तो बहुत होने चाहिए ना, बड़े कुछ मैं जो ब्लैंक्स छड्डे ने, डाउट तो बहुत होने चाहिए। ਤੁਹਾਨੂੰ ਕੀ ਪਤਾ ਲੱਗੇਗਾ, ਅੱਛਾ ਇਹ ਟੌਪਿਕ ਪੜ੍ਹ ਰਿਹਾ ਇਸ ਸਟੇਜ ਤੇ ਪੜ੍ਹ ਰਿਹਾ, ਜੇ ਤੁਸੀਂ CPC ਪੜ੍ਹ ਰਹੇ ਹੋ ਤਾਂ ਜਦੋਂ ਵੀ ਤੁਸੀਂ CPC ਦੀ ਪਾਰਟਿਕੂਲਰ ਪ੍ਰੋਵੀਜ਼ਨ ਪੜ੍ਹੋਗੇ ਤਾਂ ਤੁਸੀਂ ਇਹ ਪ੍ਰੈਜੈਂਟੇਸ਼ਨ ਆਫ ਪਲੇਂਟ ਜਾਂ ਡਰਾਫਟਿੰਗ ਆਫ ਪਲੇਂਟ ਤੋਂ ਲੈ ਕੇ ਡਿਸੀਜਨ ਤੱਕ ਤਾਂ ਪ੍ਰੋਸੀਜਰ ਅੰਡਰਸਟੈਂਡ ਕਰਦੇ ਹੋ ਤਾਂ ਤੁਹਾਨੂੰ ਪਤਾ ਲੱਗੇਗਾ ਕਿ ਇਸ ਪਾਰਟਿਕੂਲਰ ਪਾਰਟ ਤੇ ਇਸ ਦੀ ਰੈਲੇਵੈਂਸੀ ਹੈ। ਹੁਣ ਤੁਸੀਂ ਜਦੋਂ ਡਿਫੈਂਡੈਂਟ ਦੇ ਤੌਰ ਤੇ ਪੇਸ਼ ਹੋਣਾ ਹੈ, ਮਿਸ ਜੁਆਇੰਟ ਆਫ ਕਾਜ਼ਸ ਆਫ ਐਕਸ਼ਨ, ਮਿਸ ਜੁਆਇੰਟ ਆਫ ਪਾਰਟੀਜ਼, ਤੁਸੀਂ ਆਬਜੈਕਸ਼ਨ ਲਾਓਗੇ ਤਾਂ ਆਬਜੈਕਸ਼ਨ ਲਾਓਗੇ ਤਾਂ CPC ਆਨਸਰ ਕਰਦੀ ਕਿ ਕਦੋਂ ਆਬਜੈਕਸ਼ਨ ਲੈਣੇ ਨੇ, ਠੀਕ ਹੈ ਨਾ। ਤਾਂ ਤੁਹਾਨੂੰ ਰਿਟਨ ਸਟੇਟਮੈਂਟ ਫਾਈਲ ਕਰਨ ਲੱਗਿਆ ਵੀ CPC ਨੂੰ ਪੜ੍ਹਨਾ ਪਏਗਾ, ਉਸ ਦੀ ਰਿਲੇਵੈਂਟ ਆਰਡਰਸ ਪੜ੍ਹਨੇ ਪੈਣਗੇ। ਜੇ ਤੁਸੀਂ ਐਕਸ ਪਾਰਟੀ ਹੋ ਗਏ, ਤੁਹਾਨੂੰ ਪਤਾ ਲੱਗਿਆ ਕਿ ਮੇਰੇ ਅਗੇਂਸਟ ਐਕਸ ਪਾਰਟੀ ਆਰਡਰ ਹੈ, you just move an application for setting aside the ex parte order। ਤਾਂ ਕਿਹੜੀ ਪ੍ਰੋਵੀਜ਼ਨ ਹੈ CPC ਥੱਲੇ? ਆਰਡਰ 9/13। ਤੁਸੀਂ ਪਲੇਂਟ ਪੜ੍ਹੀ, ਤੁਹਾਡਾ ਲੀਗਲ ਬ੍ਰੇਨ ਕਹਿੰਦਾ ਇਹ ਤਾਂ ਪਲੇਂਟ ਸਸਟੇਨ ਹੀ ਨਹੀਂ ਕਰਦੀ ਕਿਉਂਕਿ ਇਹਦੇ ਚ ਅਵਰਮੈਂਟਸ ਹੀ ਨਹੀਂ ਹੈਗੀਆਂ, ਕਾਜ਼ ਆਫ ਐਕਸ਼ਨ ਹੀ ਨਹੀਂ ਬਣਦਾ। ਤਾਂ ਆਰਡਰ 7/11 ਤੁਹਾਨੂੰ ਰਾਈਟ ਦਿੰਦਾ ਹੈ ਕਿ ਮੂਵ ਐਨ ਐਪਲੀਕੇਸ਼ਨ ਫॉर ਰਿਜੈਕਸ਼ਨ ਆਫ ਪਲੇਂਟ ਬਿਕੋਜ਼ ਇਟ ਇਜ਼ ਨਾਟ ਡਿਸਕਲੋਜ਼ਿੰਗ ਦੀ ਕਾਜ਼ ਆਫ ਐਕਸ਼ਨ। ਸੋ ਜੇ ਤੁਸੀਂ ਇੱਕ ब्रॉडर पैरामीटर अपने माइंड बना लो, ड्राफ्टिंग टू डिक्री, तो ये स्टेजेस ने, तीनों स्टेजेस से जेडी प्रोविजन पढ़ोगे वो तुम पता लगेगा कितने फिट हो रही है। ये रिटन स्टेटमेंट पे हो रही है, ये एविडेंस पे हो रही है, ये ड्राफ्टिंग पे हो रही है, या ये एविडेंस पे हो रही है। जो तुम ये क्लैरिटी होगी कि केड़ी प्रोविजन दी किस टाइम पे सिग्निफिकेंस है, इनकी पार्टी लूजेस दी गेम, अदर पार्टी विन्स दी गेम, जेडी पार्टी हार गई वो की करे, अपील फाइल करेगी। तो CPC ਦੇ ਵਿੱਚ appellate jurisdiction भी discussed। In the civil law there are two appellate jurisdictions, one is vested with the district judge, another is with the high court। तो ਤੁਸੀਂ appellate jurisdiction ਨੂੰ understand ਕਰੋਗੇ, memo appeal, it is called memorandum of appeal, how to prepare it, CPC will give the answer। ਤੁਸੀਂ appendix ਚਲੇ ਜਾਓ, you will get the draft also। ਸੋ ਜਦੋਂ ਤੁਸੀਂ ਅਪੀਲ ਫਾਈਲ ਕਰਨੀ ਹੈ ਤਾਂ ਅਪੀਲ ਕਿਹੜੀ ਕੋਰਟ 'ਚ ਫਾਈਲ ਹੋਣੀ, ਅਪੀਲ ਦੀਆਂ ਰਿਕੁਆਇਰਮੈਂਟਸ ਕੀ ਨੇ ਉਹ ਤੁਹਾਨੂੰ ਸੈਕਸ਼ਨ 96 ਐਂਡ 100 ਦੱਸਣਗੇ। ਉਹਨਾਂ ਦੇ ਨਾਲ ਰਿਲੇਟਡ ਪ੍ਰੋਸੀਜਰਲ ਪਾਰਟ ਦੇ ਵਿੱਚ ਆਰਡਰ ਦੱਸਣਗੇ, ਮੇਬੀ ਆਰਡਰ 47। appeal ਦੇ ਵਿੱਚ when you are preparing the memorandum of appeal, you have to understand what are the parameters to challenge a particular judgment। ਤੁਸੀਂ ਉਸ ਫਰੇਮ ਦੇ ਵਿੱਚ ਆਪਣੇ ਕੇਸ ਨੂੰ, ਬਟ ਫਸਟ ਐਪਲੇਟ ਕੋਰਟ ਰੀਅਪਰੀਸ਼ੀਏਟ ਕਰ ਸਕਦੀ ਹੈ ਐਵੀਡੈਂਸ ਨੂੰ ਵੀ ਔਰ ਪਲੀਡ। ਬਟ when you are filing the second appeal before the high court, ਤਾਂ ਸਿਰਫ substantial question of law j involved hai, only then you can maintain your second appeal, otherwise your second appeal will not be successful। इसी तरह there are other jurisdiction, review, revision, reference, इस तरह ਦੀਆਂ jurisdiction भी है। रिव्यू कदों फाइल कर सकते हैं, रेफरेंस कदों फाइल करवाई जा सकती है, रिवीजन कदों फाइल की जा सकती है। सो दीज आर आल्सो द jurisdiction of the civil courts in the hierarchy of civil courts। बट ये सारा कुछ अंडरस्टैंड करने की बजाय जे आप ये समझिए कि दो बंदियां का आपस में डिस्प्यूट है, वो कोर्ट चले गए, तो तुसी एज ए लॉयर की करो, आई हैव टू रेमेडीज। डैमेजेस दी मैं डिसाइड कर लिया कि डैमेजेस क्लेम कर, सिविल सूट फाइल करांगा डैमेजेस, तो की प्रोसीजर अडॉप्ट करना पड़ेगा, तुसी मैनूं गाइड। यस यस नो व्हाई
बट सर स्टूडेंट को भी तो प्रूव करना पड़ेगा, जब आप
एक ना
होंगे तो यूनिवर्सिटी को भी
हाँ
प्रूव करना पड़ेगा।
हाँ
उसमें दोनों पार्टी
मैं क्यों पूछ रहा हूँ इसके पीछे कारण यूनिवर्सिटी को कहूँगा अपने स्टूडेंट्स को बुलाओ और पूछो, प्रोफाइल करो, डिस्कवरी नहीं मिला तो डिफरेंट चीज है, नहीं मिला तो डिफरेंट चीज है,
नहीं मिला,
हाँ नहीं मिला तो शूट लूज कर जाऊंगा,
वो फाइल ही नहीं होगा या कॉपी
नहीं फाइल तो होगा, तो मैं उसमें एप्लीकेशन फाइल करूंगा इंटेरोगेटरीज एंड डिस्कवरीज। यूनिवर्सिटी बिहेवियर है पॉजिटिव है, वो कभी भी एडवर्सरियल एटमॉस्फेयर में नहीं जाएगा, ना वो मेरी फेवर में है ना स्टूडेंट्स की फेवर में, तो इट इज एक्सपेक्टेड दैट यूनिवर्सिटी विल बिहेव एज अ इंडिपेंडेंट पर्सन। तो वो आपसे एक इट इज अ डेफामेटरी अगेंस्ट द यूनिवर्सिटी, जिम्मे फाइल दिस इट इज अ डेफामेटरी, दो कॉज ऑफ एक्शन है उनके पास। हाँ कॉज ऑफ एक्शन की बात आ गई तो सिविल सूट में कॉज ऑफ एक्शन की बहुत इंपॉर्टेंस है।
सम एक्शन हैज डन,
नहीं एक्शन तो एक्शन आ गया ना, कॉज का कॉज मीन्स द बंडल ऑफ फैक्ट्स व्हिच गिव्स यू द राइट टू एक्ट, दैट कॉज ऑफ एक्शन accrued within the jurisdiction of that particular court। अब कोर्ट फीस कैसे पे की जाती है? कोर्ट फीस एक्ट है, वो प्रिस्क्राइब करता है प्लेन पे कितनी लगेगी, लेटर स्टेटमेंट पे कितनी लगेगी, सब्जेक्ट मैटर पे कितनी कोर्ट फीस लगेगी, वो कोर्ट फीस एक्ट है। तो इसके बारे में क्लियर हो गया। सो वन पार्ट इज सिविल सूट, राइट फ्रॉम ड्राफ्टिंग टू डिग्री, देन द अपील बिफोर द फर्स्ट कोर्ट एंड द सेकंड कोर्ट एंड स्कोप ऑफ द अपील। अब डिग्री पास हो गई, इट हैज बीन अप एंड अप टू द हाईएस्ट कोर्ट, अब हमने उसको एग्जीक्यूट कर दिया, ऑर्डर 21 छोटा सा ऑर्डर, सिंपल ये है कि आफ्टर द डिग्री हैज अटेन्ड द फाइनलिटी यू कैन मूव टू द सेम कोर्ट फॉर द एग्जीक्यूशन ऑफ द एग्जीक्यूशन मीन्स सपोज स्पेसिफिक परफॉर्मेंस ऑफ एग्रीमेंट हैज बीन अलाउड, the other party may be directed to execute the sale deal। तो आप एग्जीक्यूटिंग कोर्ट में एप्लीकेशन डालोगे, देयर इज ए कंप्लीट अगेन फॉर्मेट, इट इज प्रोवाइडेड इन द अपेंडिक्स आल्सो, यू जस्ट फिल अप दैट एंड फाइल इन द एग्जीक्यूटिंग कोर्ट, व्हिच इज द एग्जीक्यूटिंग कोर्ट। इवन इफ अ डिक्री हैज बीन upheld up to the Supreme Court, it is the first court, court of first instance, which is the court of execution। तो अगर सिविल जज ने पास किया डिग्री तो सुप्रीम कोर्ट ने फाइनली डिग्री पास कर दी, तो कोर्ट ऑफ फर्स्ट इंस्टांस इज द एग्जीक्यूटिव कोर्ट। आपने वहाँ फाइल करना, नोटिस होगा, देयर इज अ प्रोविजन फॉर अटैचमेंट ऑफ प्रॉपर्टी, देयर इज अ प्रोविजन फॉर सेल ऑफ प्रॉपर्टी, देयर इज अ प्रोविजन फॉर डायरेक्शंस टू द डिपेंडेंट इन अ पर्टिकुलर वे, बट द एग्जीक्यूटिंग कोर्ट कैन नॉट फॉर्मुलेट इट्स ओन डिसीजंस। The law is the executing court cannot go beyond the decree. Whatever the court is only bound to execute the same, to give it the reality, to give those rights and duties executed, but cannot form its own opinion. Executing court is bound by the decree. Suppose the court has held that B may be directed to execute the sale deal, then the executing court only direct the B to execute the sale and A may be directed to deposit the balance sale consideration if at all. But the court, executing court can't say that decree can't be executed because it is not possible to get the sale deed executed. So let the other party may compensate the other party with this amount. No, executing court has no jurisdiction to amend, alter or vary the original decree. It cannot travel beyond the decree. Then there is a provision for attachment of the property. Attachment means a clause is attached to the property. I can't sell it. I can't create any right, maybe mortgage, lease over this property. The property is attached. Then the court has the jurisdiction to even sell this property to satisfy the decretal amount if some amount is there. So by way of auction under this provision of the executing court, this property can be sold also in open auctions, and whatever the sale proceeds are there, it will be given to the decree. Then one example, house, my only livelihood and the living space is my house. It may not be attached, it may not be sold in the execution with certain rights. So this is the process of execution of the deed. Yes. ये तो वही टीचर वाली बात हो गई, बस आगे लेक्चर डिलीवर कर दूँगा. Just ask. Yes.
So interpleader.
इंटरप्लेटर क्या होता है? डिस्प्यूट हो गया आपका और इनका. बैंक कहता है किसको दूं? आपने सिविल सूट फाइल कर दिया, तो बैंक कैन बिकम अ पार्टी टू इट एज ए वन, और द बैंक कैन इंस्टीट्यूट अ सेपरेट सूट एज ए इंटरप्रेटर सूट एंड से प्लीज गिव मी द गाइडेंस, गिव मी द लॉ और डायरेक्शन, टू whom should I disburse this? This is called interpreter suit, where third party has no interest but to get the adjudication of the rights of 2 other 3, 4, 5 parties to discharge their own liability. That is called interpreter suit. अब इसको क्लियर करो.
Enact हुआ होगा.
एज ए लॉ स्टूडेंट क्या टर्म यूज करो?
So enact हुआ होगा. Enact.
नहीं, कुछ आंसर मिलेगा, क्लैरिटी हो. गलत होगा क्या बात? यस.
An act is only on one.
बहुत अच्छा लगा, मैं वही कहता हूँ, गलत पूछो बट अल्टीमेटली हम किसी चीज का आंसर तो लेंगे ना, कुछ क्लैरिटी तो होगी.
बहुत सारे वर्ड.
बिल्कुल ठीक है, हम प्रोसीजर अंडरस्टैंड करते हैं. प्रेसिडेंट ने साइन कर दिए बट वो लॉ नहीं है, वो लॉ ऑफ द लैंड नहीं है. तो किस दिन लॉ ऑफ द लैंड बनेगा? जिस दिन गजट पब्लिकेशन. थोड़ा सा डिफरेंस था. आपने ये कहना था कि ऑफिशियल गजट में उसकी पब्लिकेशन, जिस दिन वो नोटिफाई हो गया इन दी ऑफिशियल गजट, इट इज़ दी लॉ. हाँ, उसमें अगर जैसे BNS था, ये पब्लिश तो हो गए 23 में, लागू हुए 1 जुलाई 2024 में. क्या मतलब? अब आप कहोगे कि आप कॉन्ट्राडिक्टरी स्टेटमेंट दे रहे हैं. नहीं, नोटिफाई हो गया, उसमें डेट भी लिखी होगी, that it shall be applicable from this particular date, or it shall be applicable from the date of notification, or it shall be applicable from this particular date, or it shall be notified subsequently, like in BNS and BNSS. उन्होंने डेट नोटिफाई नहीं की, तो बाद में एक नया नोटिफिकेशन आया जिससे उन्होंने तीनों एक्ट्स को नोटिफाई किया that these acts shall become law of the land and notified with effect from 1st of July 2024. तो लॉ कब बनता है? जिस दिन वो ऑफिशियल गजट में पब्लिश होने के बाद उसकी डेट ऑफ नोटिफिकेशन भी होती है. राइट. इग्नोरेंस ऑफ लॉ इज नो एक्सक्यूज. क्यों कहते हैं इग्नोरेंस ऑफ लॉ इज नो एक्सक्यूज? क्यों कहते हैं?
Because everyone is presumed to know that.
यस. पब्लिकेशन का मतलब क्या है कि दिस ऑफिशियल गजट इज नोन टू ईच एंड एवरी सिटीजन ऑफ दिस कंट्री. वो पढ़े चाहे उसमें लैंग्वेज कौन सी, तो ईच एंड एवरी सिटीजन इज प्रिज्यूम दैट ही इज अवेयर ऑफ द लॉ. ठीक है. अब और पूछो, हमारे पास 10 मिनट है. कुछ पूछो रैंडमली, कुछ भी गलत पूछो, कोई प्रॉब्लम नहीं है, बट वी विल रीच टू अ सर्टन गुड कंक्लूजन. यस, कोई डाउट नहीं है यार, इतने एक्सपर्ट तो नहीं है. कारण कोई जस्टिफिकेशन तो होगी उसकी लॉ सब्जेक्ट के साथ.
Yeah, I would prefer, but I would prefer more on civil services.
ओके.
Like,
आप
लिटिगेशन सर.
लिटिगेशन कहाँ पे?
चंडीगढ़ और मध्य प्रदेश.
चंडीगढ़ है.
चंडीगढ़ और मध्य प्रदेश भोपाल.
यू बिलोंग्स टू मध्य प्रदेश. तो एक लेटेस्ट इंसिडेंट हुआ मध्य प्रदेश का, क्या हुआ? तो प्रैक्टिस कहाँ, हाई कोर्ट में करना चाहते हो डिस्ट्रिक्ट कोर्ट में? डिस्ट्रिक्ट कोर्ट में.
स्टार्टिंग फ्रॉम डिस्ट्रिक्ट.
इंटरनेशनल लॉ. आप सर दिल्ली क्या करना चाहते हो? प्रैक्टिस लिटिगेशन. तो बिलोंग दिल्ली से करते हो? हाई कोर्ट या डिस्ट्रिक्ट कोर्ट? आप बताओ. लिटिगेशन कहाँ पे? यू बिलोंग्स टू हरियाणा. आप जुडिशरी जज बनना चाहते हो? वेरी गुड. आप बताओ.
Government jobs.
गवर्नमेंट सर्विस, लॉ रिलेटिंग या कुछ नहीं? लॉ रिलेटिंग। आप सर आपसे पूछ रहे PCS जुडिशियल और एग्जैक्ट। हाउ मच एफर्ट यू आर पुटिंग? आपने शूज़ खरीदने, हाउ मच एफर्ट यू आर पुटिंग? 4 शॉप्स में जाओगे, साइज भी चेक करोगे, ब्रांड भी चेक करोगे अगर ब्रांड की चाहत है। So whether you have assessed yourself for a particular job, one, what are the intricacies and intricacies of relating to that job or a service or litigation? Have you evaluated that? भाई पहले evaluate करो। आपने लॉ में एडमिशन तो ले ली ABC रीजंस के कारण, but now if you have decided to build your career in a particular direction, evaluate yourself, your interest, your strengths and weaknesses, one, and second, whatever profession you are going to choose, उसकी क्या प्रॉब्लम्स है, उसके पॉजिटिव्स क्या है, उसके नेगेटिव्स क्या है, मेरे को क्या फेस करना पड़ेगा, क्या मैं सस्टेन कर पाऊंगा या नहीं कर पाऊंगा, एटलीस्ट उसका ब्लूप्रिंट बना। यू हैव 1 ईयर में, चाहे वो इंटर्नशिप ज्वाइन करो उस फील्ड में, वहाँ जाके देखो उस फील्ड को वो कैसे वर्क करता है, प्रिपेयर योर ब्लूप्रिंट एंड देन जंप इनटू दी सी। विश यू ऑल द बेस्ट, गॉड ब्लेस यू। कभी भी किसी भी तरह की कोई क्वेरी हो उसको आप सब्सक्राइब कर लेना, कहीं ना कहीं कुछ ना कुछ आपको इनपुट मिलेगा। थैंक यू वेरी मच, गॉड ब्लेस यू।
Insightful and engaging lecture. Your clarity in explaining complex concepts and real-life examples you shared made the session both informative and memorable. It was truly a privilege to learn from your expertise, sir. Thank you once again for your valuable time and your enriching understanding in the subject of CPC. We hope to have the pleasure of welcoming you again sometime in the future. With this, I request Karandeep sir to please present a token of appreciation.